Welcome to Grow For It. It's a podcast for small business owners, managers, and professionals. The goal is to give me a chance to work with the space between your ears, on your mindset, to help you focus on the things that really matter to your success. I want to enable you to concentrate on pursuing your vision, setting meaningful goals, and engaging in the day-to-day activities that will have the biggest impact. Thanks for joining me. Friends, welcome back. I've got a guest in the studio today. This is attorney Parker Wornall here in Louisville. Parker's been on a few times. In fact, he was on the radio show that I did back in 2018. And one of the reasons I wanted to bring him on today was to talk about, as we look at business startup issues, as we look at different issues that a business owner has to grapple with on a day-to-day basis, a lot of us have different notions about, well, what type of business are we really talking about? Well, Parker's actually developed a niche in the healthcare arena. And I thought this would be an interesting opportunity to kind of bring him in and have him talk to us a little bit about some of the things that he counsels his clients on. And this could also be applicable to some point outside of the healthcare arena if you're a business owner. But I thought this would be an interesting niche opportunity. So, hey, Parker, welcome back, guy.
Hey, Jim. Thanks for having me again.
Absolutely. Well, let's jump into this. Now, when I say healthcare companies, a lot of people are thinking, well, are you talking about big hospitals? Are you talking about Humana and Aetna and things like that? That's really not the scale that we're really talking about. You've actually got a niche in dealing with smaller healthcare companies. Do you want to kind of give us an idea of what that might be made up of?
Yeah. So the typical healthcare provider client for me is your, it's the equivalent of a person with a law degree going out and hanging a shingle. It's the people that you see in the strip centers, the standalones. These are typically, dentist offices, specialized areas such as, foot and ankle doctors.
Right. You get into into mental health, like a psychiatrist or a psychology practice.
Sure. Yeah. Psychiatric offices. One of the developing trends here over the last few years has been with nurse practitioners, APRNs, who have gone out and established either, testosterone clinics, weight loss clinics have, they've been a big trend in recent years. So those types of things. Adult day healthcare programs. Even we have
those were really big a while back, and I guess they continue to flourish as our population transitions a little bit.
Yeah, absolutely. So there is, and this is a completely different topic, but there is a huge amount of the population that is moving out of business, moving out of their homes. They're going to have, the need for these adult day healthcare programs, and we have a few clients that have found a way to start to meet that need. The disparity between the population amounts and the boomer generation and those moving kind of into those needs, there are really a lot of interesting developments in healthcare needs just based on sheer volume as our nation gets older.
Well, and then as you find yourself in these conversations with people, I mean, one of the things to think about is that, these things are pervasive. If you drive down the road and just look how many dentist offices do you see, how many therapy offices, how many of them, I mean, they're everywhere. And sometimes when you hang out that shingle, you start off saying, it's kind of like the law firm hanging out a shingle, a solo practitioner or a small boutique practice. A lot of times you know your trade very well, but the business aspects are something that maybe you're not as solid on, and that's why you might bring in an office manager or you might bring in some other advisors, and you're one of those advisors. Now, you're with the Commonwealth Council Group here in Louisville, and you've got a group of people, a group of partners you work with, and what I find is kind of interesting is you're not just a transactional attorney, you're not just doing contract work, you're actually also a litigator.
Correct, yeah. So, excuse me. I kind of run the gamut. So litigation is a big front door for us, and it's how we get a lot of our clients that then I stay on as kind of a general counsel in order to prevent future litigation. Ideally, I like to get in with proactive clients that look and they say, I'm a nurse practitioner, but I have no idea how to run a business. And, in truth, I'm probably not going to be the complete fix for this is how you run a business, this is how you crunch your numbers, this is how you do that, all that and the other. So I partner with some CPAs. I partner with other good resources. I've spent the better part of the last 4 years developing a really good network of trusted people and other contractors for various needs. But the lens that I always look at business through is through doing it safely, growing safely, and insulating yourself against liability. So when a proactive client calls me and, ideally this is at the very beginning phase, they say, I want to start a company. I say, well, that's great. We start to look at how many partners are you going to have? Are you a sole practitioner? Are you going to have, people that you're doing business with? Then we start looking at corporate structure. Most of these provider entities are likely going to be PLLCs or just regular LLCs. There's some interesting things you have to work through when you have non-provider members in a company, which a lot of people do.
And by non-provider, you mean somebody who is not actually a doctor or a nurse, somebody, and you're talking about more staff members, what all does that include?
Right. So this is even at the organizational level.
Wow. Okay.
So say you have, you're a doctor and you have somebody else that is going to be the business and the pockets. Those are less common, but they're, I've certainly seen plenty of them where you have a non-doctor stepping in and
more of an investor or kind of a silent partner or
sure.
somebody that's just going to bring the money that's going to help start the practice.
Yeah, or acting on the board of directors, right. Depending on the corporate structure. And, another interesting thing is that there's a hot modern trend where, people are developing these practices and then they will sell out after a few years to your Nortons, your Baptists, your bigger entities.
Right.
But, selling a business takes a lot more forethought than somebody making you an offer and you say, oh, okay, here's my book for the last month, take it and do with it as you will. So if you get out in front of it far enough, there's a lot of things you can do with, structuring your shares. You might want to look and see if a professional services corporation is a better option for you than an LLC.
And again, this all comes back to the entity startup. This is really at the core foundational moment that, hey, I think I'm going to open a business. Open a practice.
Correct. This is just getting going. And there are some things you can do after the fact. So you've got an LLC that needs to, change into a corporation just to become more marketable. There's a hot mergers and acquisitions market out there rather. So some people, I've gotten calls when they start to just get offers from somewhere in the wind saying, hey, we want to buy your practice.
Right.
They look at me and they say, we need to change some things. And those changes can be made, but they're always easier just to
get it right up front.
Just to try to think, hey, in 5-10 years, are you going to be thinking about selling? Are you going to think about opening this up to, different kinds of shareholders? Do we need to focus on classes of stock? Things like that.
At the same time, do you foresee additional facilities, additional branches, additional offices? Are you going to grow? Maybe you're going to grow within Jefferson County, or maybe you're going to grow regionally. All of that takes a little forethought, and having somebody like you up front that can really help plan that out, so you kind of have a general idea and the legalities of doing so. It's a lot easier to do, like you said at the very beginning. Now, once everything gets going, I mean, you do have these compliance issues, especially in healthcare, highly, highly regulated, and I think that's where a lot of the times an independent practitioner may know his or her compliance issues, but from a business standpoint, they're even broader, and that's where I think people kind of get in the gray area or trip over that border, and suddenly they're in violation of something, and they weren't really aware of it. That's one of the reasons they need to bring you in on these. You want to talk about some of what you do with these compliance checks?
Yeah. So typically, one of the things when I have a new client that is a provider, the first thing I'll do is I'll look at all of their forms. I'll look at their patient intake forms, their disclaimers, their waivers, this, that, and the other. And COVID has really brought a lot of this to light, just how diverse your series of compliances are that you kind of have to go through, because now you look at you're a business owner. Especially during the pandemic. Now you've got all these things from, different governmental entities that are imposing restrictions on you. You've always got employment compliance with the Department of Labor, the Kentucky Wage and Hour, federal wage and hour laws, Fair Labor Standards Act. Things like that are things providers don't even think about usually.
And that's that whole employment law side of it where, okay, is this person an employee? Are they a 1099? You've got all these other things that you've got to worry about. And again, that's part of the structure, part of getting up and going.
Yeah. And and I'm glad you brought us to that, and then I'll get back into the healthcare compliance area of it. But Most things that people don't think about. So you take a provider that is specialized in his or her respective field, and he or she is a great tactician in what they're doing, with their hands and their mind every day, but that's completely different than running the business. So, there may be the realization that, hey, I need to hire an office manager, and I might need some help, hiring some techs. Well, all of those employment structures are probably going to look different. You might have a couple groups of here are our administrative staff, here are, here are some of my techs that are going to come in and help, but they all have different degrees. They all have, different things they bring to the table. Some are going to be salaried employees, some are going to be 1099, and that can even happen if you say you're a growing practice, take a psychiatric practice or a counseling practice, for example. There are situations where companies basically just lease a room, the proverbial chair and the couch,
Yeah.
to a provider, and they say, okay, you're an independent contractor. You come in, you bill as you will. We'll take care of the billing and all of that, but you handle the clients, you set your schedule, you do this. Those are pretty clearly going to be independent contractors. Others, they're going to say, I want a set schedule. I want you to feed me clients. I need this type of structure in my life. We say, okay, well, you're going to be a salary, and those can both be equally qualified providers. One of the big front doors into how I get these clients is the disparities that exist between the Kentucky regulations and the DEA regulations. This is particularly prevalent within testosterone and estrogen clinics.
In the DEA, that's more at the federal level versus the state level.
Correct.
Okay.
So the Kentucky regs and the DEA regs, there are some pretty significant differences between them, and it's ever evolving. I mean,
Right.
These things as the nation and the state look at the opioid epidemic, and I'm interested to see the wave that comes out of the rise in opioid use after COVID, how some of these regs are going to again be shifted. But even when you look at testosterone, it's pretty heavily regulated, and everybody thinks, oh, you just go out, you get a testosterone prescription, you go on with life. Well, that's not exactly the case, and a lot of nurse practitioners have entered their practices with that same mindset, and then you find out when you get a mean letter from the Kentucky Board of Nursing that says, we ran a Casper search that looks at, all the prescriptions you've given out in the past, say, 6 months, and we found 120 prescriptions that are not within Kentucky regulations. That's a tough situation to be in. So,
Yeah.
I like to avoid those on the front end. Unfortunately, not a lot of people have, know they need it until they, get something like that, and then we can only try to prevent future instances once we get that issue taken care of.
Well, you brought up something a little while ago. You've got obviously regular staff, but you've also got assistants and other practitioners that will be working in the organization. There's this whole issue of having the right insurance as well. I guess as a business owner operator, you've got to be thinking about your insurance exposure. So should something go wrong, should somebody file a claim against your insurance. Malpractice insurance is one big thing, but knowing who needs to be covered and how, I mean, that's, again, a conversation that you should be able to add some value to, I would think.
Yeah, so I have a handful of good commercial insurance agents that I partner with that are used to working with providers, and we can, it kind of create, and I like to serve in this role. When we're working with CPAs, it's always best when the business owner, myself, and the CPA are on the same page. When we're linked on correspondences, when we get on conference calls, I do the same thing with with insurance providers to make sure that there's adequate coverage. I tell them how we're trying to grow, what this is going to look like, whether that be more employers in the coming months, whether that be opening another storefront, whether you are transacting business now, which is a current trend that has really escalated during COVID. Telehealth,
Yeah.
that has its own special set of needs. And there are certainly not a shortage of companies out there that, you know, are HIPAA compliant and can, provide streaming and software that will help you out with that. So there's plenty of resources. It's just, kind of knowing where to look and having been in the game before and knowing how to find them.
But again, if you're a practitioner, you're worried about treating patients. I mean, that's really what you want to do. And all these other things just kind of slow you down and take you away from the thing that you're really good at. The thing that actually generates revenue for the organization is you treating patients or clients in the office. All of these other things, you've got to really have a good quarterback on the team. And it sounds to me that that's really kind of your role as general counsel when you come into these organizations. I like what you said about really making sure that the other people, the CPA or whomever, is on the same page, because sometimes they look at it from one perspective and you look at it from a legal perspective, and sometimes if you're just communicating separately to the business owner or the practitioner, that advice may not always line up. So it's nice to kind of have you guys communicating off the same sheet of music. I think that makes a lot of sense in streamlining and avoiding exposure or miscommunications. Now, you also, as part of the dealing with the employees, you also deal with what we always hear is non-compete issues, and that could be a restrictive covenant is I guess the legal term, but it's also whether or not somebody whether you can defend it, saying, hey, that employee can't go to work for you because I have this non-compete, or if you're trying to hire an employee who says, well, wait a minute, I've got this issue. You want to talk about that for a little bit?
Yeah,
because that comes in even outside of healthcare, obviously.
Correct. Yeah, this is widely applicable, and Kentucky actually favors the enforcement of restrictive covenants, which I'll give a definition to here in a minute. But there are some very narrow hoops that have to be jumped through in order for a business to be able to enforce these. And too often, I'll have an employee that is leaving a company that's like, hey, can you look at this for me? And I'll find some pretty glaring holes. Now, that's not to say that just because you think you can pick a non-compete agreement apart, that it is going to avoid litigation. There's still the possibility that you as an employee leaving a company will have to defend yourself and pay to do so just to prove you're right. But a lot of companies are very cavalier in the drafting of their restrictive covenants, and they're not sufficient under Kentucky law. So that's another service that I provide to my providers now. Some providers, the more gregarious ones, which is not uncommon for people in the medical field. You go into the medical field and you want to help people. So it's not uncommon for my clients to say, we'll hire whoever we want, and we're not going to tie restrictive covenants to them. We don't want to ruin their ability to go out and earn a living after this. Others do, and that's not to say that they're mean people. They're just trying to protect a business that they're growing, right. Which is why Kentucky looks at this and says we're going to enforce these. So, what are restrictive covenants? There are essentially three types. There are non-compete agreements, which have to be narrowly tailored as to purpose, geographic scope, and duration, essentially. And there are tons of nuances in there, but I'll leave it at that for now. Separately from that, and this is where a lot of businesses and employees have some confusion, is separate from that is a non-solicitation agreement, which means that an employee can't go out and solicit a certain client base, certain vendors. Non-solicitations have even been attached to other employees saying, hey, you can't leave and take our office staff with you. And those,
a lot of times we call it poaching. You can't leave the company and come back and take all the clients with you.
Correct.
Yeah.
So non-solicitation looks like that. Since non-solicitation clauses are typically tied to an identified class of people, like clients A through Z, they don't have a geographic scope requirement because they have already preset requirements. But there is a time requirement that is set, and that can waiver depending on the company, the employer, or the employee, what's being protected, this, that, and the other. The third restrictive covenant is a confidentiality provision. So in healthcare, particularly the more specialized you get, you may have specialized equipment, processes, practices. I've even seen with some of my chiropractic clients that the layout, the flow of their office, and the process by which they implement their equipment is different in the chiropractic world. A lot of people think you go in there, you torque them, then you put them on the little rolling machine in the back, give them an ice pack, and send them out the door. Well, I have a client that has a very specific layout. They have new cutting edge equipment, and the methodology by which they implement all of those is something worth protecting. And they're a growing practice.
And that's akin to a trade secret almost, right?
Correct, and that's typically what it is. So, within the healthcare field, you have HIPAA on the one hand, which is it's a whole different animal that actually doesn't even it doesn't even provide a private right of action, which is what a lot of people think. So it's a very, very unique set of laws, I'll say. But so HIPAA that goes into kind of the initial ongoing compliance check. And then when you get into confidentiality, yeah, these are things that are more attached to you as a business than you as a provider.
Okay.
Now they can be you as a provider, but typically they are, they're still going to be your client lists, your billing, certainly your insurance rates. You can really get into some hot litigation with insurance companies for disclosing what rates they're paying out to you because it varies from provider to provider.
Right.
Even
So
for the
maybe
same
you've
services.
negotiated a certain rate on certain procedures or processes, and so you don't want that getting out.
Right, and the insurance companies don't want that getting out either. So
Exactly.
it can really roll downhill. But all of those sorts of things and confidentiality agreements, depending on what you're protecting, can look a lot of different ways. And have a lot of different requirements, just depending on the restrictions you're trying to put on somebody. But again, they have to be narrowly tailored, and you can't just say, you figure out what our trade secrets are, because we already have both a state and a federal Trade Secrets Act that kind of give a definition of misappropriation, trade secrets, things like that.
And again, sometimes these disagreements can be, I guess, worked out through negotiations and letters back and forth, but sometimes they actually go to court. Sometimes these go to full-blown litigation. And again, the fact that you're very comfortable in a courtroom is, kind of a nice aspect of your practice, because again, not everybody goes to court. Some people like to look. I'll review the contracts. I'll do all this, but if it goes to litigation, I'm going to hand it off. But you're actually a litigator as well. So again, you kind of get both perspectives in dealing with you as an attorney.
Yeah, so one of the things you get is that I have, on several occasions, both drafted and then subsequently enforced the restrictive covenants for the same company, and where the value add there is, and I have told clients that I have engaged in trade secret litigation for that don't have these agreements. You do have a little bit of a fallback. You've got the Kentucky Uniform Trade Secrets Act. You got the Defend Trade Secrets Act of 2016, which is the federal act. But these contracts save so much litigation on the front end. It's thousands of dollars worth of initial briefing and clearing your initial hurdles just to establish that something even is a trade secret. So when you look at your restrictive covenants, really what you're trying to get out of them is looking forward and say, hey, if I have to go to court, I want these elements tied down so we're not caught up in briefing, motions to dismiss, that we're not spending significant amount of time in discovery and then in subsequent motion for summary judgment briefing, just trying to figure out the basic hurdles. So
and that time also equates to money. So it's a cost savings measure for your client.
Oh yeah, you're looking at, say you give me a basic contract for a provider that comes in. It's going to be, they're usually somewhere between 4 and 8 pages, depending on your practice, what all duties and restrictions you're going to put on them. But you're looking at spending hundreds of dollars to get that in place. If you don't have that in place and you're trying to pick up the pieces later in the game when you're on the courthouse steps, about to file your complaint, that turns into several $1,000s really
I
easily.
would think so very quickly, because there's a lot of time that goes into building that documentation trail.
Yeah.
Now, you also one of the things you work with is hiring, firing, and restructuring. And those areas seem so simple, but they're not always so.
So, excuse me. So I initially started getting another angle of the complexities of hiring and firing when I started picking up plaintiffs' employment cases. And I do those very, very selectively.
And a plaintiff employee would be an employee who's maybe been dismissed and disagrees with the decision, right?
Correct. And is looking to, looking for redress through either the Kentucky Human Rights Commission or the EEOC, and then litigation after that if, those avenues are not fruitful. So I started looking at it from a plaintiff's perspective, and again, I'm mostly on the business side. I do still have plaintiff's cases. I do still take them on a very selective basis. But everybody has competing interests, and what I offer is to make both sides see that. I say, here's your employee. Here's what they're looking at. Here's your potential liability from dealing with this particular employee. Say their uniquity is, their age, sex, religion, disability. As of a few months ago now, their sexual orientation. And that's not to say, treat them like the hot potato, but they can be. It really came to a head when all of the COVID shutdowns started to happen, and people were going through layoffs, and that was a little more understandable. Companies going through furloughs and things like that. The more interesting part was in trying to bring employees back on, especially older employees who were saying, I'm over 60, I don't want to come back to work because I'm more at risk. And then you're sitting here saying, well, this person is clearly covered by the Age Discrimination and Employment Act. And now they're saying they want, but they're saying, I want to come back, but I can't right now because of COVID. And you're saying, well, you can't leave the door open forever, but I also don't want to fire you. So lot of complexities there. It's scary for me stepping into a new company and seeing that, some people may have 20 employees and 15 of those have wildly different jobs, and nobody has a contract, a job description, anything. And that's not to say you're sitting here handing out 1-year term contracts. They're typically still at will, unless you're dealing with, a CEO or other officer. Most of your contracts are still going to be at will, but they put in there things that are going to protect you from litigation, and in the event that you end up in litigation is really what you're looking to get out of a contract.
And you mentioned the term at will. Kentucky's an at will state regarding employment. And that basically means, hey, if I don't like your haircut today, I as the owner, can dismiss you. Why is that a problem in terms of litigation and things? Again, I guess when it trips over that, is that Title IX, all the protected classes, and gets into EEOC claims? Is that where it really gets murky?
Yeah, so that's both under the Federal Civil Rights Act, and the Kentucky Civil Rights Act has your pregnancy discrimination, disability discrimination, age, sex, religion, yada yada.
That's a legal term, right?
Yada yada is a legal term. Yeah, USC 19. So that's another point. Every contract that I'm going to put in says, nothing in here that we've talked about takes away the presumption of an at-will employment. So we can still fire you because we don't like your haircut. But one thing that you try to do is to say, okay, I know my industry. I know how people typically screw up when they're going to screw up and what creates a fireable offense. So, a nice thing for a good tailored contract is to look at a particular employee and say, these are the potential liabilities that he or she's going to be exposed to. These are the potential areas where he or she can really screw up. And if he or she does these things, then I'm going to fire you. And what that does is, it's not necessary completely because we are an at-will state, but it takes away the prospect of litigation. Because if somebody goes to the EEOC and they say, well, I was fired because I don't know, for whatever reason. Yeah.
Right.
And our argument is that they cussed at a client, and they say, well, sure, I cussed at a client, but it was just an off day. And you pull out a contract and you say, here it says, if you cuss at a client and you do it once, I can fire you. The EEOC is going to shut that down pretty quick.
Yeah, because that is in essence a contract
Yeah.
that you will voluntarily signed up for.
Yeah.
Now you also get into something that I would think for healthcare is, in addition to a lot of other types of companies, workplace investigations. Kind of walk us through what some of those are.
So these are interesting, and they're usually now outsourced. So most entities now will have an HR rep, or they'll have an entire HR office with a few reps, or they outsource it to a third company. And a lot of those people do most of the factual gathering and work. But there are those instances where you have to put fact and law together and say, is what happened here, or is what we think happened here, is this actionable? What's our exposure to, what's our exposure to the company? So it's not so often that I'm going in and, pulling people out of their offices and doing pseudo depositions where I've got them sit down in front of me in an office and I'm grilling them. No, I've been part of those. Usually it's HR going around talking to people first, and they come to me and they say, here's what we think we've got or what we may have. What does this mean from a legal perspective? And those can be, those are typically things you try to get out in front of too with your contract. Anything that you think an employee can do that might be investigation worthy, you want to go ahead and say, this is for cause. We can terminate you.
This could be an employee who's stealing medication. This could be somebody that's dealing with financial transactions who suddenly is not putting all the dollars in the till, things like that, embezzlement and theft. This is kind of what you're talking about in terms of workplace investigations.
Correct.
So these are internal investigations.
Yeah, and take take your providers and the the skimming medication off the top that you just brought up. There is an obligation to report to the Kentucky Board of Nursing or the Board of Medical Licensure, whether it's a nurse or a doctor doing it. But there is some due diligence that can be done up front. Double checking your charts, making sure that you have procedures in place for wasting and dispensing medication. This can save both your entity and your employees, whether they be doctors or nurses. Can save everybody a lot of heartache because all too often, particularly larger hospitals, are very quick just to pull the trigger, file the complaint with the Board of Nursing, let the Board of Nursing do the investigation, which is not an improper remedy.
It's available to them.
It's available. In some instances, I think it's a little hastily done and maybe even a little lazy.
Well, even as a patient, I may go to the Board of Nursing and say, hey, look, I was uncomfortable with the process, the procedure, the advice, that somebody made an offhand comment, somebody touched me inappropriately, all these other things. I mean, these are reasons for the Board of Medical Licensure, dealing with physicians, or the Board of Nursing, Board of Chiropractic. I mean, all these different professional organizations have their own policing side of it, their own licensure side of it. That is one of the areas where you can come in and work with the individual, though, correct?
Yeah.
The individual provider, I should say.
Correct. So that can, if you get a patient complaint filed with any of the boards, I don't know if I want to say it's one of the nice things, but one of the consequences of that is typically when the board is handling a matter, most other state agencies, particularly the police, will just kind of let it go, let the administrative agency handle it.
Kind of defer to it in general? Or?
Yeah.
Okay.
Now I have had some nurses that have been caught up in both the criminal side and have had an ongoing Board of Nursing case. But, most often the state is going to look at it and say, well, we already have these protocols in place that are specifically designed for nurses and doctors. Whether they be stealing medication, this, that, or the other. A lot of that is typically handled within the agency, and once the agency handles it, the issue stops spreading there. But, there is the possibility for civil suits from that patient that are, that's typically going to be an insurance claim, and then the insurance company is going to farm it out to, a large insurance defense firm, particularly if it's malpractice. But there's a lot of work that can be done on the front end to kind of pump the brakes and to diffuse the situation, and hopefully get your provider on at least a more narrow path towards resolution of that, instead of just having all these potential liabilities outstanding.
Right, and you don't ever want to let that wait, because there's a time limit involved, and you have to take some kind of proactive. That might be a response, that might be a petition, that might be some kind of answering of a legal document that came your way, or administrative document that came your way as a provider.
Correct.
Now, when we were talking about entity setup and entity startup, there's another issue out here that you also get involved with, and that's a certificate of need application. Walk us through that. These CONs, what are those?
So, certificate of need is a process which has actually been done away with in several states, and there have been rumors going around in Kentucky that Kentucky's going to get rid of it, but they haven't yet. It's still very active. So, certificate of need pops up when you are. It's typically small providers. Take say an ambulatory surgical center. A ton of what we've dealt with is, as I was talking about earlier, the adult day healthcare programs.
Sure.
And essentially what the state does is say that, we don't need an adult day healthcare program on four corners of every block of Louisville, Kentucky. So, and there are different levels. So when you have an adult day healthcare program, CON, there's a presumption in favor of granting. Whereas, say, if you are an ambulatory surgical center, you have a much...
Would that be like an outpatient surgery center?
Yeah. Okay. So, okay. Yeah. An example of one is an ophthalmologist.
Okay.
One that's, performing eye surgeries, LASIK, things like that.
Yeah.
And is trying to set up a standalone shop where he or she can, perform those operations. There's a much higher burden there to show that... I mean, you have to do demographic study. You have to show... Here's the amount of the population. Here is that population honed down to who's actually looking for, my specific service. Here are the other providers. Here are, how many people those providers are treating. Here's how many I think I could treat that they're not treating. So it's a big process, but...
So I can't just go hang out a shingle and then say, look, I'm going to put 4 or 5 offices here in Jefferson County. There's a whole administrative process that would kind of preclude me from doing that. So
yeah.
If that's my vision, I need to get somebody involved like you who understands the process and can walk me through it. Does that also apply to dental offices and chiropractic offices and things like that?
No.
Okay.
So this is typically, the more specialized you get, think of, so most specialists still require a referral,
okay,
from a general practitioner. So think of those people. Anybody who you need a referral to get a foot in the door. Now, not all of those are going to need a CON, but the more specialized, the more you get into, specific procedures, things like that, or when you can. And the state puts out guidelines every year that says, here are the CON requirements for this year if you're looking to open up in 2020. And they change frequently, so you often have very narrow windows to act. And then, the interesting thing is on the other side of that is the opposition. So, within the adult day healthcare field, if you have one of those CONs or several of those CONs, you don't necessarily want other people getting those. So while they may have the presumption, which typically prevails, you still want to go in there and oppose it and say, look what they're not, there's no unmet need that this new provider is offering. They're just further saturating the field.
Right.
When you step into more specialized areas, like say take an ophthalmologist, you have interest from really large hospitals that are looking for that ophthalmologist to not open their own standalone ambulatory surgical center.
That's a threat to a revenue stream altogether.
Exactly.
Yeah. Yeah. So
because typically what you have is, they will fly under the tutelage of, say, a Norton or a Baptist, what have you, and there's typically no problem. But, if you are a specialized provider who has your own patient stream, who thinks you can float your own office and you'd rather fly your own flag, then that option's available. The state just, makes you obtain one of these certificates of need.
Okay. And again, there's a full legal process. There's an application process. There's all this stuff that again, the provider doesn't necessarily have to worry about. You can handle that for them so they can get back to doing the things that actually generate revenue for the practice.
Yeah. Now, they will have involvement in that
yeah.
in helping, get everything together. I mean, they result in full-blown hearings where, the providers are going to have to go and show up, but it's several $1,000s worth of legal work. They're very intensive processes. But you're exactly right. No provider should ever hope to sit down in front of a CON packet. I mean, the CON packets put me to sleep.
Just Google it.
Yeah, they put me to sleep. So I can't imagine being a provider and trying to prosecute one of those of my own.
Okay, so let's fast forward. Let's assume somebody listening to this podcast actually has an ongoing practice, and maybe they're kind of getting to that point where they're thinking, well, maybe it is time to transition. So now we're talking about sales or transfers, or maybe I'm just going to wind it down and dissolve the practice altogether. Maybe the partnership's breaking up. Maybe I want to merge with someone else, or quite honestly, maybe I just want to sell it. Maybe I just want to sell it all straight out and walk away and enjoy the vacation. How do you get involved there, and what kind of things can you do in those relations or in those situations?
Sure. So it's all circumstantial. Sometimes, like I said, there's a hot market out there for mergers and acquisitions. So sometimes I'll just have a client that gets an offer from somewhere out in the stratosphere, and they say, "Oh, well, this is interesting." That is very rarely, if ever, going to result in a sale then. But it turns into a conversation of, say you start marketing for offers. Is that something you're actually interested in, or were you just seeing what somebody thought your business was worth? Because at that point, this goes for every type of entity. Most people don't think about selling their business until it's too late, and then everything is kind of particular to you, the owner, and it's not really geared from sale. This is everywhere from vendor contracts to the books, to your employment contracts, to your lease. What does that look like? What's your business strategy? There's a ton of things. So I have a couple really good referral sources that are business brokers that have been great assets to have to be able to say, okay, well, let's go start here. Have he or she give you a look, maybe do a preemptive valuation, see what type of valuation you want to build your business towards, which type of valuation is going to be most favorable given your setup. I would say conservatively, people should start thinking about trying to sell their business 9 to 12 months before ever putting it on a market or ever taking a serious bid.
Wow, and that's just to kind of make sure the table's set properly, make sure the due diligence on your inside, so you can evaluate that offer that comes through. And I guess there would also be the issue of, well, competitively, I don't want people to know I'm leaving the market. That could hurt me in the interim. So I want to do this quietly, so I could work through you as a proxy.
Yeah, absolutely. And a lot of this is behind the scenes. This isn't necessarily marketing your company for 9 to 12 months. A lot of this is just dealing with your organizational. Like say you're going to sell out to a private equity firm. A lot of those are going to look at different class structures for stocks. They may not be as interested in you just having an LLC that has one class of membership, and that class being, if you have membership, you have an ownership interest. Sometimes there needs to be arrangements where you need to transfer some of your percentages to non-ownership interest, or non-voting rights, rather. So there's a lot to think of there, but the other side of that, I guess to put a cap on that is adding value to your company that you can easily just flush away because you take an offer and you decide to sell it.
Right.
That said, I do handle a ton of those. The typical vehicle is an asset purchase, where and I like to work, especially with providers, I like to work with CPAs on this to figure out how everything is going to be identified. What portion of it is buying the good faith, what portion of it is buying the dental chairs, things like that, so that taxes are well considered during the sale of the company. But I piece those together all the time. Somebody says, I got an offer, I'm 70 years old, I've been doing this long enough, I want to sell it off to somebody. and I can reduce that down to an agreement with relative ease, depending on how the parties are structured. It's always easier if there's two attorneys on either side of the table. That way we can, work through the weeds together. And those are rarely contentious. Now, I've had some dissolutions where you have people in a business that just need to get the heck away from each other.
Right.
But one of the dangerous things on the front end is, everybody knows how to open a business and make money. And people that do that on the front end and don't think about their operating agreements or their share structures, things like that. Well, 5 years down the road, when the deal's blowing up and you've got one person that wants to fly a flag on the left and one person wants to fly a flag on the right, and you need to get the entity dissolved. I've stepped into situations like that have taken several months to get the parties away from each other. So that's that kind of brings full circle how it can be it can be really helpful and financially beneficial to be proactive and prudent when you are, when you're even just thinking about beginning to transact business.
Right. And so in that entire business life cycle, from conceptualizations to, hey, we're actually going to start a business, to managing it in the interim, we're going to hire, we're going to expand, we're going to do all these other issues and deal with the regulatory body, to that eventual wind down and sunsetting when I'm going to walk away from it and again enjoy the rest of my life. That entire life cycle is something that Parker Wornall, you can handle and advise for a client. If somebody's interested in talking to you, what's the best way for them to get a hold of you here in Louisville?
Sure. So our website is www.ccgattorneys.com. My email is parker@ccgattorneys.com. So that's CCG as in Commonwealth Council Group, attorneys with an S.com. Office number is 502-805-2303. And that's 502-805-2303. That rings straight through to my cell phone. So I'm always available. Initial consultations are free. I can usually get it, watered into about a 20-30 minute conversation to assess your needs, figure out where you are, where you need to go. And then I typically ask for a follow-up narrative. If you are, say you're in litigation, I'm going to ask for a narrative that you email to me and all documentations. If you're somebody interested in a startup, there's a different set of needs. But the front door is wide open. And Jim, the interesting thing about these general counsel representation arrangements is that I'm there monthly. Sometimes I'll have providers that I'll go 2-3 months without hearing from them, and then they'll have something pop up. I think my clients in particular are surprised at how approachable my services are. Everybody thinks, particularly people that have had experiences with larger firms where maybe billing is not as flexible and a little less intimate. I'm a small business owner myself, so I know what they're looking at on their end because I'm looking at that from our vendors.
Yeah.
I think people are surprised at the value of services they can get from me for a very approachable price point. And that is, that's just something that people need to. Some of this work is front loaded, especially when you're starting out. But as you're ongoing, it can turn into, maybe you need me for an hour a month, maybe it's 5, maybe it's nothing.
And there's a lot of different ways to structure that relationship based on the need of the client.
Correct. Yeah, but you call when you need. If you're in hot water, we get you out. But
try to anyway.
Yeah, we try to. But the general approach is to get a proactive client and to help them avoid the hot water at all.
Yeah.
And that's the most fulfilling for me, and those are the client relationships that I love the most.
Well, Parker, again, you've been a guest on this podcast and on other venues a number of times, and I really appreciate your advice. I really appreciate talking to you through business. You've been very, very much involved in the growth of my business here, so I always appreciate that advice. And again, it's a pleasure to see you. I know you're busy, but I really appreciate the time with you. So that's always fun to have you in the studio. Friends, I hope you found this episode interesting. I hope you found it helpful. If you are thinking about starting a healthcare practice, if you're dealing with one now and you think you need to look for an attorney or seek some advice, I'd encourage you to reach out to Parker. Again, he's been instrumental in the practice that I'm trying to build here. It's not healthcare related, but nonetheless. But friends, once again, thanks very much for your time. I know you all are as busy as well, and if this is something that piqued your interest, I'd just ask you to go back and look at some of the other options out there. I've got a number of blog posts on the website. I've got a number of podcasts out there, and you can find that everywhere. I mean, if you can find those on JimRayConsultingServices.com. You can find them on Apple iTunes, which is now Apple Podcasts, Google, Spotify, just pretty much anywhere. But I appreciate your time. So when you're ready, give me a call and let's grow for it. Take care.